হ্যালো ফ্রেন্ডস, পশ্চিমবঙ্গ তথা ওয়েস্ট বেঙ্গলে শিক্ষক নিয়োগকে কেন্দ্র করে বহু মামলা, সেটা হতে পারে এসএসসি বা আপার প্রাইমারি, কিংবা হতে পারে প্রাইমারি শিক্ষক নিয়োগকে কেন্দ্র করে। আজকে আমি তোমাদের সামনে অনস্ক্রিনে তুলে ধরতে চলেছি একটা গুরুত্বপূর্ণ মামলার আপডেট, যেটা গতকাল অর্থাৎ 19শে জুন, মানে 19/6/2024 কিন্তু তার শুনানি প্রদান করা হয়েছে অনারেবল জাস্টিস হরিশ টন্ডন এবং অনারেবল জাস্টিস প্রসেনজিৎ বিশ্বাস বিচারপতি দ্বয়ের ডিভিশন বেঞ্চে। তো আজকে আমি তোমাদের সামনে সেই লাইভ আপডেটটি কিন্তু তুলে ধরতে চলেছি আর কিছুক্ষণের পরে। তো তোমরা অনস্ক্রিনে যারা রয়েছো এই মুহূর্তে পুরোপুরি ভিডিওটি লাস্ট পর্যন্ত দেখো, কারণ এই ভিডিওটিতে তোমরা কিন্তু আপডেট পাবে, সঠিক আপডেট, যেটা হচ্ছে 2022 শিক্ষক নিয়োগ মামলাকে কেন্দ্র করে যে মামলাটি করা হয়েছিল, বা শিক্ষক নিয়োগকে কেন্দ্র করে যে মামলাটি করা হয়েছিল হাইকোর্টে, সেটার আপডেট। এবং তার সঙ্গে সঙ্গে সেই শিক্ষক নিয়োগের পাশাপাশি কিন্তু একটা রিজার্ভেশন মামলাও জড়িত ছিল। তো সেটার সম্পর্কে কিন্তু আজকে কলকাতা হাইকোর্টের ডিভিশন বেঞ্চের বিচারপতি দ্বয় হরিশ টন্ডন এবং প্রসেনজিৎ বিশ্বাস কিন্তু সেই শুনানির কিন্তু একটা নয়া মোড় কিন্তু ঘুরিয়ে দিয়েছেন। তো তোমরা পুরোপুরি সেই লাইভ আপডেটটি কিন্তু অনস্ক্রিনে দেখতে থাকো, কোনোরকমভাবে স্কিপ না করে। আর যদি আমাদের এই ভিডিওটি ভালো লেগে থাকে তাহলে অবশ্যই একটা লাইক করো এবং শেয়ার করে দাও যদি ইনফরমেটিভ মনে হয়। আর তাছাড়া যদি তোমরা আমাদের এই চ্যানেলে নতুন হয়ে থাকো তাহলে অবশ্যই চ্যানেলটিকে সাবস্ক্রাইব করো এবং পাশে থাকা বেল আইকনটিকে প্রেস করো। তাহলে চলো আমরা সেই লাইভ আপডেটটি দেখে নেব।
I will ask him. What is this? My lord, this is against, my lord, the order dated, my lord, 9th October 2023 at page 42.
Affidavits are complete.
Affidavits are complete.
Direction by affidavit opposition
Affidavits are complete.
complete.
Well, I think, my lord, there is no dispute in regard to facts.
Let me go to the order.
Yes, sir.
Delay has been controlled.
Yes, my delay has been cut. No,
Order dated 9/10.
9/10.
9/10.
9/10.
Give us just take your seat. Give us 1 minute. Whether for what
My lord, I'm for the Bhojwal Board of Primary Education.
they are bringing to the OBC E category. The dispute appears to be there.
That.
He applied in both general category candidate as well as the
No, my lord, he applied for, my lord, sat for TET as a general category.
So she wanted her consideration to be made under
Proposed. Now I tell you losses, my lord, here. I give that.
Absolutely.
My lord, in this appeal, I have taken
What was the last day of submission of the application?
last day of the submission of application 3rd November 2022.
What, November?
3rd November 2022. My lord, I have taken 2 points before your lawsuits here. Though this was decided without calling for any affidavit, that's not. First point to your lawsuits, that he appeared as a general category candidate, and when the last date also was over, he didn't possess the OBC B certificate.
That's why I asked.
That's your loss. That's the first point.
29th November is the date when she was
Exactly.
handed over.
The second point I have taken, which was not urged before the single bench because this was not called for affidavit, he appeared as with a B.Ed qualification. Now, the B.Ed qualification, Supreme Court has declared not entitled to be for recruitment of primary teachers. My lord, this is a TET for primary teachers. So the TET qualification also requires training qualification, that is DLED, Diploma in Elementary Education. So, the Supreme Court declared that those qualifications, notifications declared unconstitutional by NCT, issued by NCT, and declared that those persons are not entitled to be appointed. Now, this judgment was passed, your lordships, on 11th August 2023. Now, I have taken this point. Now, there is a further little development, your lordships, that this judgment was modified to the extent that those candidates in the meantime appointed with the B.Ed qualification, their service should not be deserved. But even then, your losses, my learned friend cannot get that benefit because he has not yet been appointed. He is only TET qualified. So TET qualification is not saved. Third now, my lord, because of the pendency now, my learned friend's certificate issued on, my lord, 15th.
9/11/2022.
That's he has according to obtained hard copy. Issued according to him 15th September 2022. Malad, by the judgment of our High Court, all the certificate goes. Recent judgment. I'm coming to that. That's another point. This is the point I have not taken, but this is the law now. So Malad, I take your losses. The first point, your losses, that 3rd November 2022, he obtained the last date of submission. Whether a candidate can claim
Yes.
whether a candidate can claim that benefit. This is the facts.
Was the condition there as on the date of the application?
Malad, TET notification, your losses will get at page 27. Now, your losses, Malad.
Substantially by the other page.
No, this was not hard. Only
I find.
yes, hard. This was hard, but ultimately affidavit directions called for. Only Malad, I'm sorry, Malad. The bench observed verbally that they should not proceed with the contempt application. That's the only thing. In the meantime, contempt application has been filed. Notification for conduction of teacher eligibility test 2022 for classes 1 to 5 by West Bengal Board of as per the NCTE guidelines. Now, all concerned are hereby notified that the West Bengal Board of Primary Education has decided to hold teacher eligibility test 2022 on 11th December 2022 throughout the state in exercise of statutory power. The West Bengal Board of Primary Education hereby notifies to conduct TET examination for the purpose of recruitment of assistant teachers in government-aided, government-sponsored junior basic primary schools for classes 1 to 5 to be held on 1st December 2022, 11th December. Only those persons, your lordship, this is also important, who have acquired the academic and professional qualifications specified in the NCT guidelines 25th August 2010. I'm going to pause here for a moment. This says 25th August 2010, only DLED candidates are qualified for recruitment and TET. Recruitment.
In 2018.
In 2018, my lord, extend this to the B.Ed candidates. This notification has been quashed by the Supreme Court. This 28 June 2018.
What about 21?
21, my lord, 31. That's my lord, fall out of that. That's not my lord. If the parent goes, then everything goes. That's the fallout of the my lord, 28th June. That I will show to your laws are eligible to apply for. So, my lord, I have taken, then your losses will find the qualifications. Now your losses clause 2. Persons who have appeared for final examination of 2-year DLED course from NCT, the result is not yet published, are have appeared examination special education are also entitled. Then your lordships, persons who have appeared for final examination of Bachelor of B.Ed course from recognized NCT nor is yet to publish shall also be eligible to appear. Now, my lord, this clause also hit by the Supreme Court judgment because B.Ed qualifications have been said to be not ineligible. Said ineligible, I will show the judgment. Now, my lord, kindly see your lordship, last but one paragraph. The details regarding the submission of the online application form will be available on or after such and such date. And the last date of public candidates, my lord, the last date of submission was,
Where you are reading?
my lord, the last but one
Submission.
submission. The details regarding the submission,
After 14/10/2020.
that will be available. And the last date was, your losses, 3rd November, I've taken note, my lord, 3rd November 2022. That your losses will not get it over here, but that's admittedly the date. I would like to call your attention, this was addressed to the Secretary of the Board, to the fact that Soma Sahabishas, a candidate of state examination held on 11th December 2022. My roll number was such and such. I belong to OBC family. I applied for the OBC certificate on 26th August 2021. I am sorry to say that I received OBC certificate number after completion of the form fill up of primary state examination 2022, but it was issued on 15 September 2022 from the Ranaghat subdivision office, and I received the hard copy on 29th November 2023. Malad, here your losses will find, if I am not wrong, whether your losses copy are legible or not, probably 2022. But the paragraph says 2023 from Gram Panchayat office. So I had to sit for the primary state examination as a general candidate. That after the publication of the result of primary state examination, I discovered I obtained 84 marks. Malad, as a general candidate, 84 marks is Malad, not a pass mark. He failed according to us. 90 is the pass mark. If he is OBC, then he is pass. Mark, which is the qualifying mark for the reserve category, not for the general. This is a heart-rending news and all that. So, Malad, admittedly, on the date of form fill, the last date, even on the date of examination, he didn't have the OBC certificate. Now, Malad, I just showed you losses the one judgment on this one Supreme Court OBC. Supreme Court judgment 2005, 12 SCC, page 498. দেখ আমাকে একটা দিয়ে আনে যা কি করে it's a very short judgment. I place it to your lordships. Heard the counsel for the appellant, all counsel for the contesting respondent. The first respondent submitted an application for appearing in the combined competitive service examination for filling up the various posts in the state of Jammu and Kashmir. The examination consisted of 3 types, namely the preliminary examination, the main examination, followed by interview. The last date for submitting the application for preliminary examination was 16th March 1999. The first respondent submitted his application in time, and the application he did not indicate that he was entitled to the benefit of SRO 126 of 94 dated 20th June 1994 issued by the state of Jammu and Kashmir, whereby the reservation was granted to the residents of the backward area and the line of actual control. The preliminary result was published on 15th May 2000, and the first respondent qualified himself in the said examination. The application was called for the main examination, and the last date for submitting the application was 23rd August 2000. And the first respondent submitted his application wherein he indicated that he was entitled to the benefit of SRO 126 of 1994, dated 20th June 1994. The Appellant Public Service Commission considered the application of the first respondent and took a decision that he was not entitled to claim benefit of reservation by virtue of the SRO 126 of 1994, as he had not claimed the same in the preliminary examination, and the respondent was not included as a successful candidate in the category of reserved persons who are entitled to the benefit of SRO. The first respondent thereafter challenged the selection by filing a writ petition. The learned single judge of Jammu and Kashmir held that the first respondent not entitled to the benefit of SRO, as he had not indicated in his application for the preliminary examination that he was entitled to such benefit. The writ petition filed by the first respondent was dismissed. He challenged the same by way of a intercourt appeal probably, and the division bench of the High Court, Jammu and Kashmir, held that the first respondent herein in fact possesses the eligibility for being considered in the reserve category even before the date of advertisement, and he submitted his proof only later, and that by itself did not disentitle him from killing the reservation. Accordingly, LAP allowed direction to treat him in reserve category. This was challenged before us. The Learned Council for Commission submits that as the last date for submitting application 16th March 1999, the respondent did not produce the certificate claiming reservation, nor did he indicate in the application that he belongs to that category. It was submitted by the several other applications of similar nature was rejected by the Commission, and the respondent's application was also treated alike. And the division bench erred in coming to the conclusion that he was entitled to get reservation. Counsel for the respondent, on the other hand, pointed out that though the first respondent did not avail of the benefit of reservation when he submitted the application for preliminary examination, he had submitted the application for the main examination in which he had clearly shown that he was entitled to the reservation, and he had also produced the certificate along with the application for the main examination. It is submitted that he had claimed for reservation for the main examination, and he should have been treated.
The main one, paragraph 5.
Paragraph 5. Versus this cannot.
Once he has applied,
Exactly.
he has an option to choose. Has opted for a particular option that as a general candidate and not under the reserve quota or the reserve candidate. Then later on he cannot turn around and say that I should
Exactly, that's-
consider a son. That was a different case because there were 3 tiers of the examination. Application was made in the first tier as
As a general.
candidate. Later on came to know that he has been included under the reserve category. So the second tier of examination wanted his consideration and
Exactly. But here you'll,
perspective.
I tell you losses, here your losses he applied as a general category. And then he plucked.
Whatever. That's your contention that once he has chosen
Exactly.
to offer his candidature as a general candidate or general category candidate, he cannot switch over.
No, this is the other end, a little extension, your losses. He has obtained the certificate after that.
That is a different. That is a.
That's your losses. He cannot claim the benefit of that in this examination. And the second point, your losses, as I placed your losses, the B.Ed qualification. B.Ed qualification is one of the qualification was for appearing TET. Normally, Malad, it is DLED. He didn't have DLED. Now, B.Ed qualification, I give you losses. I think my learned friend has annexed in the affidavit in opposition. Kindly take up, that would be Malad, the Supreme Court judgment. Well, that's at page 33
of the opposition.
of the opposition. That's similar downloaded copy, but in any event, your losses. I will show the only, well, it's a big judgment, I will show the only relevant paragraph. Well, the first paragraph your losses will find at page 33. This emanated from the Rajasthan High Court judgment, whereby the notification of the NCT was quashed. We also challenged it in this application here in the our High Court, and all together taken to is a pan-India notification. Now your losses will find the first division under challenge before this court, apart from appeal settlement, all before on the same issue, dealing with the cases, all your losses. The third paragraph, what lies at the core of the dispute is the notification dated 28 June 2018, which entitling the B.Ed qualified candidates. Now your losses, that notification, your losses will be getting that notification at page 56, internal page 26 of the judgment. Page 56, the last. The inclusion of B.Ed as a qualification, as you also got, was done by the notification dated 28 June 2018, which was impugned before the Rajasthan High Court. Kindly see the national education. In exercise of the powers, all that your losses makes skip it over. NCT has the authority. In the said notification, in para 1 in subpara 1, in clause A, after the brackets, graduation and 2-year diploma in elementary education. This is the basic qualification. The following shall be entered: graduation with at least 50% marks and bachelor of it. This was questioned before throughout the country, and this was ultimately your losses will find what has been held by the Supreme Court. I give you losses some of the paragraphs. Paragraphs Malad, kindly come to page 66 onwards. Under these circumstances, we are unable to comprehend as to what the pressing need to include B.Ed candidates who are admittedly not fully trained to take up primary classes. Consequently, the decision of the NCT to include B.Ed as a qualification for teachers in primary school seems arbitrary, unreasonable, and in fact has no nexus with the object sought to be achieved by the Act, Right to Education Act, which is give the children not only free and compulsory but quality education. But I just take your lordship, pause for a moment. I just tell your lordships, these B.Ed qualification earlier also was sought to be included by government notification in our state. My lord, in Dilip Ghosh's judgment, the division bench presided over by the Honorable Justice Subbu Kamal Mukherjee held that this cannot be done. This is not a higher qualification. This is a different qualification. That judgment was also upheld by the Supreme Court. Supreme Court has also considered that judgment in this matter. In our considered opinion, therefore, NCT was not justified, paragraph 34, in including B.Ed as a qualification for appointment to the post of primary school teacher level 1, a qualification it had so far consciously kept out of the eligibility requirement. The Rajasthan High Court, by of the impugned judgment, had rightly struck down the notification 28 June 2018 on the following grounds. The impugned notification is unlawful because it is the direction of the central government which the power the central government under subsection 1, section 23 of the Right to Education Act, and they did not have. It is not in exercise of the central government under subsection 2 of section 23 of the RTE Act. Then the petitioners have no locus standi to challenge the notification. Well, here that notification was questioned by the B.Ed qualified candidates. Merely because an additional qualification is recognized as one of the eligibility criteria. Accepting a candidate with B.Ed degree as eligible for appointment and thereafter subjecting him to complete bridge course within the 2 years of appointment is in the nature of relaxation. Your lordships kindly take up the page 30, the 56, 57. Your lordships will find a, well, your lordships kindly take it up, that notification impugned. Now kindly see clause A, 2A, who has acquired the qualification
Course of 6 months.
Exactly. Therefore, this was a ground.
Already read that.
This was already a ground taken. That therefore it itself shows that the B.Ed is not a qualification. So, my lord, then your lordships will find 35. One inquiry must for dealt with that one which much emphasis was laid down by the appellant, the central government. I think those are now, my lord, paragraph 73, my lord, page 73, the third paragraph. But as we have seen, the decision to include B.Ed as a qualification is not an independent decision of NCT, but it was a decision of the central government, and NCT was simply directed to carry it out, for that being a direction under section 29 of the NCT. Well, Act contemplates the NCT being an expert body has to decide which will be the qualification. What they did, my lord, certain central government school, Kendriya school, they applied before the central government the relaxation of qualification for certain time. That was taken by the central government as a ground for inclusion of it and directed NCT to do it. That was a ground that this was not the exercise done by the NCT, and therefore the entire notification is unconstitutional. And this was held by this, your lordships.
Anyhow, the ultimate decision,
Ultimate-
inclusion of the B.Ed as a qualifying, as a qualification for the teachers in the primary school
Now,
is against the provision of the Constitution.
the point arose now thereafter by way of a miscellaneous application judgment. I give your lordships. Hey, একটা দিন যশ আমার কাছে আছেন kindly consider paragraph 8 first. If I wrong, I will stand corrected. I was.
Yes. Subcategorization
Exactly.
is more backward, B is backward.
Yes. Well, kindly come to page 190. Kindly consider paragraph. I just tell your lordships the paragraph. Paragraph G. Paragraph 9.
Of which paragraph? That subparagraph G.
Page 190. This is a continuation of the paragraph direction under the heading directions B. Page 190. The executive orders number 6390 BCW dated 24th September 2020.
Yes.
Kindly see the executive order 6309 dated 24th September 2010
Yes.
and the other one after issued by the government of West Bengal backward classes welfare device sub-classifying one starts down. This sub-classification means, my lord, categorization A and B. My lord, it might, my learned friends might be OBC, but sub-categorization goes.
But kindly see H.
Classifying the 143 classes
Exactly.
are struck down.
By this notification, one of the notification, your lordships, 24th December,
But kindly see.
24th September 2010.
This is not a debate, sir.
I'm sorry. Am I please?
Where do I get it, this particular executive order dated 24th September?
Just I take your
In the certificate, it is not mentioned.
certificate doesn't mention at all.
It is mentioned in the certificate, Lordship. Kindly see 36 page number. Notification is 1996. It is not of 2010.
No, I'm talking about 2010 notification,
I just
24th September
tried to
2010. Where is that?
That's right. Give it to us.
These are the notification relating to 94, 96, 97, 96.
I mean, দেখলাম Honorable Line.
This category B was much prior to those, and they are declaring this category in terms of the earlier notifications. Then what this judgment says that the executive orders classifying 66 classes prior to 2010 are not interfered with.
That's only that is saved.
So if it is prior to 2010 notifications, then
It is of 1996.
66 classes. We do not know that what are those 66 classes.
But I just
Whether this
66 it falls within the 66 somehow.
Chachi community has been included in 66, or it is subsequently included in 143.
All right, my lord, I will check it up and then tell you.
Don't argue something which is because what has been caused is 143 classes, 35 classes.
এগুলো বল সবগুলি বল আমি জাস্ট দেখতে হবে কোন
Those
প্যারাগ্রাফ
have been
paragraph 5 only says, your lordships, between 1994 to 2009, 15 years, on the recommendation of the commission, the state included 66 classes. Paragraph 5.
the ultimate is that it has not, when this judgment does not declare all the classes to be, all this OBC, the certificates to go.
No, certainly not.
Simply says that there are certain classes which were included subsequently as an OBC 1, A or B. Those classes were not done in tune with this. And then also says 66 classes which were there earlier prior to 2010. Those are saved.
Malad, I will just, Malad, I am concerned with this, Malad. I make out your case. Malad, before
But paragraph 5 says that between 1994 to 2009,
Exactly.
On recommendation of the commission, the state included 66 classes as OBCs, which comprised of both Hindus 54 and the Muslim 12 communities.
Matlab, this is saved.
That is what I'm saying. So whether this particular community Sachasi is coming within this particular 66 or outside 66, you have to specify that.
I tell you, Lordship, I will just the relevant paragraph. My point is that even if he comes within 66,
Yes.
this is OBC, not OBC-B. This sub-classification goes. Yet, your Lordship, I will show to them.
No, understand whether we have to see by virtue of this 94, 96 notification, whether there was already a subclass or subcategory or
No.
that we don't know unless
Malad-
there is a material.
That's my Lord, paragraph 6, 7 and 8. Your Lordships will find that. The first sub-classification is 2010. In the earlier, your Lordships find only OBC certificate. From 2000 September onwards to 2010, sub-classification comes. I will, the relevant paragraphs, I will, Malad, your 6, 7 and 8, your Lordships will find.
No, it does not say so.
Malad, paragraph 8. 24th September 2010.
No, paragraph 8 I'm looking at.
Yes.
It says subcategorizing the OBCs into two categories.
This is the first sub-categorization.
That is the 56 class as OBC 1,
And 52
OBC
classes
and
OBC.
OBC B.
This is the first sub-categorization.
Let us see. Anyhow, we have to go through the judgment, otherwise we can't.
My point only, Malad, he might be OBC, but that this certificate doesn't survive.
Maybe this is neither here nor there, and anyhow, it requires more facts to be gone into, and this cannot be done in an appeal.
The certificate goes, I cannot declare, Malad.
No, you can't take it something which is factually required to be considered. Then
All I
Order,
tell you,
Order 41, Rule 27 will stare at your face. These are the additional evidence you really wanted to rely upon.
then I have to bring it by an application.
It's a pure question of law, that is a different. But if it is a mixed question of fact and law, then
I'll try, Malad, the other paragraphs if I possible.
sorry, then we will not go into this.
Yeah, factual involvement, I am not invited, your Lordships.
That is what you can't do it. Otherwise, you'll have to take out.
No,
an
if I can
application.
show your Lordship the category V for the first time 2010, then he goes.
No, it is what a judgment is a pure question of law if you want to rely upon a judgment. But if the judgment is decided on a parameter of certain facts, unless those facts are pleaded or brought by way of an additional evidence for first time in appeal, then you will have to
But
take.
this has happened, Malad, during pendency of appeal.
No. Then you will have to more to take note of a subsequent event, and
Yes,
then
I will
Order
recommend.
41, Rule 27 has to be followed.
All I do, your Lordships, confined to that.
No, that we can't. What is pleaded there, we have to go by that. And what is a law? No difficulty. Your contention is very, very categorical in this regard, that so far as the B.Ed, the qualification or the degree is concerned, the Supreme Court has subsequently already declared that this is absolutely unconstitutional, not in tune with the law, and therefore the B.Ed cannot be taken as a ground. And the judgment has been made to operate retrospectively only in relation to appointment already made or those who are serving. For them, it is to be made prospectively. This is what your contention is. Secondly is that once he has applied under a particular category, he cannot later on take a rebound and say, no, I should be considered under a particular.
After completion of the process.
What is say? The declaration of the result.
That's the memo of appeal, these 2 points.
These are the 2 points you have raised in this. and you have relied upon two judgments of the Supreme Court.
Yes, sir. And they want modification order.
No, that's clarification means prospective or retrospective.
That's it.
So that is restricted, retrospective for all, prospective for only those who have already been appointed. That is what is there.
Now, these concerns, my lord, only one. These judgment also, my lord, said the appointments already made.
That is what I'm saying.
These judgment also.
Prospective for them, for those who have already been appointed and rendering services. For them, for those who have not been appointed, may be selected, it will operate as retrospective. That is what is the clarification.
How do you
Yes.
Lordship, my contention in this matter, that is, firstly, the notification was published on 29/9/2022. My lord, subsequently, on 7 November 2022, another notification passed whereby it has stated B.Ed candidates are not the eligible criteria.
No, forget about B.Ed. First, cross the hurdle.
Yes, my lord.
As on the last date of making an application, you have offered your candidature as a general category candidate.
Lordship.
Subsequently, when the result was declared and you defined that you are not eligible under the general category, you wanted to switch over from a general to a reserve category. You have obtained the certificate subsequent thereto. Whether that is permissible in law. The Supreme Court judgment he has cited. Would you like to make any comment on this judgment?
Yes, Lordship.
That is a judgment in case of J.